All right, so we are beginning this lesson on the legal aspects of education and what are some legal issues that someone may encounter who is seeking to become a certified educator. Well, if someone is a certified educator, there's various legal responsibilities that they have. Forgive me, I'm pulling up my textbook here so I can have a reference to the classroom. I'm going to pull up chapter 9 in our textbook. So let's go to chapter 9. Chapter 9, chapter 9, chapter 9. Alright, beginning of chapter 9. So, chapter 9 is basically the legal aspects of education. The learning objectives in this chapter are to identify the fundamental elements and concepts in the legal system, describe legal rights and responsibilities of teachers, discuss the legal rights of students and the limitations on student behavior, and to describe the basic religious activities that can and cannot be conducted in public schools, and the way in which the government can and cannot assist non-public schools. Now, there are some things that I do disagree with in the textbook on. I'm just pointing that out point blank. Specifically regard to the last section that they talk about. But that's neither here nor there. It's just everyone has opinions, and there's nothing wrong with it. Um, so the first thing we talk about is the teacher's rights and responsibilities. So the teacher must provide they must provide a basically a certification of their teaching. They often have to go through background checks and other various legal procedures to make sure that they're qualified for their teaching. They want to make sure that they are properly qualified, I guess, properly vetted to make sure that they are capable of working with children, capable of being trusted to work with children. And there's three main ways, the teachers can be hired or onboarded by schools. These legal certification programs, these background checks, result in three main ways of teachers being hired. Now, there are some who allege discrimination in the certification processes. I in the textbook it says most lawsuits charging that teacher tests are discriminatory have either failed or been withdrawn because the available data did not demonstrate a clear pattern of discrimination nor an intent to discriminate. Now that is something that's very very interesting because in today's time everyone's looking for discrimination. They're actively looking for it. And when it's not found, it's often fabricated. Page 247 of the textbook clearly says that there's most of the lawsuits have not been successful. Some of them have, and I don't doubt that there are actual instances where people who have been discriminated against because we don't live in a perfect world. You know, we don't live in a perfect world, and so it's important to understand, what discrimination is. That's one legal issue that teachers have to deal with. What is discrimination? You know, it did someone was am I discriminating against someone else? Did someone discriminate against me? Those things happen. And there's some discrimination is good, some of it's not. And so that's not the goal of this chapter, is not to define discrimination per se, but I think it's relevant to our discussion. The three main ways teachers can be hired or onboarded is contracted. That's pretty much just a basic job contract. Basic, basic, something you sign. Hey, I work this much. You pay me this much. You know, type of thing. Um, another, another, another way is a continuing contract, which basically is the same thing. Just that a teacher doesn't have to renew it every year. It doesn't have to be renewed every so many years or every year, whatever the length of the contract is. And then there's tenured teachers. Tenured teachers, they begin with a probationary period followed by a period of uninterrupted teaching in which the institution cannot fire the instructor. There's an error in my PowerPoint there. So the institution cannot fire the instructor. There is some question about whether tenure discrimination discriminates against students. So the textbook. Let's go to the textbook on that. Page 247, maybe. Uh, let's see here. 247, 248. Some people allege that basically tenure discriminates against students in a, some people say in a couple of ways. It can put students at a disadvantage. It can say, well, I'm just here. I'm just being paid by the school. I don't have to do nothing. That type of thing. I think that's what they're talking about. Basically, kind of, it, some teachers have taken advantage of tenure laws. They've taken advantage of things that have been put in place for good, but they've taken advantage of them and made them not good. They made them bad things that they're wanting to do away with. And so, that's where we get into the dismissal of tenured teachers. Now, they do have rights under this instance too, but tenured teachers can be dismissed for a few reasons. Since the others are pretty much self-explanatory when it comes to the dismissal of teachers, contracts can be ended, not renewed. Tenured is the most complicated one to deal with because you have rights, because you're promised. It's a promise. It says tenured teachers have many protections against wrongful termination. Unions, there's teachers unions all over. Fourth Amendment and First Amendment, etc. Is it so? Tenured teachers can be terminated if there has been proof of incompetence thoroughly proven by a school board, and that takes some time. It takes some time to develop that evidence because you have to examine the teacher over a period of time. Potential speech or character lapses even outside of their jobs as educators. So, for example, just if a tenured teacher goes out and gets drunk, gets in a bar fight or drinks and then drives and has a wreck or something, that can be grounds for dismissal of a tenured teacher. At least, kind of from what the textbook says. And then another one is striking. A few teachers, I believe the textbook mentioned that a few teachers, even some who were tenured, were terminated because they striked. Now whether that's valid or not is another story. I think it depends on the circumstances of the strike, but striking in general, I think can be a good thing. It often has led to good results. Traditional values in the classroom. A lot of parents are looking for more traditional values in the classroom. They're looking for more. They're looking for things that are. I guess, putting more trust in the teachers, putting more trust in the teachers, allowing more freedom in the classroom for discipline of unruly students, things like that. And this particularly has to do with the rights of students, because while parents and a lot of schools have moved toward traditional values in the classroom, there are also laws that protect students. Obviously there's gross misconduct like abuse, sexual, verbal, mental, emotional, physical. Those things are obviously dead giveaways. But there are other things, like suspensions and expulsions. You have due process there. It's just like a job. If they terminate you for because you said something one time, that somebody didn't like and somebody got offended, well, that can be grounds for wrongful termination. It may not be, depending on what it was, but it could be. That type of thing. It's not about what. It's just, you can take it case by case. 14th Amendment. There's no corporal punishment. Corporal punishment has been outlawed in most states. There's the few states that have them, from what I understand, and I've heard, do not practice them because there's so many legal fence posts around them that they just, anything they would do would be considered harassment or abuse. There's sexual harassment, obviously. You obviously have the zero tolerance policy on weapons. No weapons on school grounds. And I'm for weapons, but I don't think children who are developing to be adults and who are not fully developed should have weapons. I don't think that they should do that, especially nowadays. There's a bunch of other protections that can be safe. There's strict liability, things like that, like when they're on the playground or whatever. There's all kinds of things that keep children safe. All of these things and more have been established to keep children safe in the classroom. Children from young age all the way up to, you know, high school and college even. So teachers must balance their rights with their responsibilities, and so do students. Students must do the same thing. Does school discipline go far enough at keeping students in line with the values of the educational system, or educational institution, rather? That should be institution. Well, depends on the case. Again, it's case by case basis. I would say, parents and teachers have recognized the need to change and are working to accomplish this goal. They recognize that there's more discipline needed to deal with unruly behavior. Teachers have been given more trust in recent years, as they had many years ago, to decide the discipline in their own classroom within reason. Obviously, corporal punishment has been outlawed in most states, so they can't use that. There's all kinds of other things. Now, this next section is where I would disagree with the textbook. Now, I will teach the textbook as it stands. Basically, they go through the various Supreme Court cases that have decided that church and state have to be separate. That's their basic premise, is that church and state must be separate, and therefore prayer and reading the Bible and things like that shouldn't be allowed in schools anymore. That's their basic premise. And they base it on many modern scholars and many modern legal scholars and legal precedents and Supreme Court cases and things like that. So that's basically what the textbook says. They in one of the cases that the textbook mentions, Engel versus Vital, it ruled that state written prayer unconstitutional. According to the court, neither the fact that the prayer may be denominationally neutral, nor the fact that its observance on the part of students is voluntary, can serve to free it from the limitations of the Establishment Clause. Just now, what definition are they using of the Establishment Clause? That's where I would disagree with the textbook. The textbook basically goes along with the idea that the Establishment Clause was meant to keep the church out of the government. That's the common view of the Establishment Clause, and that's what our textbook promotes, and that's a valid view, I suppose. But it's not really correct. When you really look at things through the unbiased lens of history, it's not really correct. There are various protections. Sure, there are various protections on school grounds that do protect religious groups. But it's not necessarily that some of these folks are wrong. It's that it's a misunderstanding, really. Recent Supreme Court cases have failed to fully clarify the issue, but it is clear that religious and other groups and activities must receive equivalent access and must satisfy criteria as the following: student initiated, not sponsored by the school, but its employees may attend meetings. Outsiders may not direct the group or regularly attend meetings. The group cannot be disruptive. Each group must have equal access to meeting spaces, school periodicals, bulletin boards, blah blah blah. So there are protections, and they do treat them, for the most part, like any other group in the school. And so that's absolutely, those legal protections are there, and those things are absolutely fine. They're great. But I disagree with the basic premise of their definition of the Establishment Clause. Like I says here, when one examines the ideals of the founders without bias, digging into the meaning, what they wrote in their private letters, there is little room for assumption that they believe church and state should be separate in the sense of what the modern definition of such is. In the 80s, there were a group of Christian parents who decided to take on the school system for teaching the religion of secular humanism. It was decided at the Supreme Court level that there was no religious influence in the schools, and that the textbooks/resources, ignoring other religious explanations, is not considered discrimination. It would be a violation of the Establishment Clause to say that any religious explanations should be taught in the public schools anywhere. But what does this clause mean? Now, the modern definition is based upon a a letter written by Thomas Jefferson to a church. It was a private letter giving a promise not to take away their rights. He wasn't giving a legal definition of the Establishment Clause. So that's important, and that's where the modern definition comes from. Again, the textbook presents it more from an objective point of view, but it's still kind of based on that definition. And I want to clarify that that definition is incorrect. If you really look at that, the definition of the Establishment Clause was meant to keep the state from controlling the church. It says Congress shall not respect an establishment of religion, and that it just basically means that Congress can't establish a state religion. It says, in summary, the legal decisions based upon the idea of separation of church and state have no grounding in the text of the Constitution because the phrase nor the idea was never inserted into it. This last legal issue is an ongoing battle between secular humanism and Christianity in the struggle for the minds of those who are most impressionable. The assumption that a judge or a lawyer is needed to interpret the text of the Constitution is absurd. The text is clear, and it should be taken at face value and not skewed by postmodern relativism, as it has been over the years. And so that's I've presented the textbook's view. I presented the textbook's view first, and then I presented my opinion based on my reading of the textbook. And the reading of the textbook is based on the modern assumption that church and state are separate, and that's grounded in our legal system somehow, and it's really not. And so most honest historians, when they read a summary of history, they'll recognize that at some point. A summary of Chapter 9 can be, teachers have rights that are to be respected with respect to their privacy and job security, both inside and outside of the classroom. Students have these same rights. Parents are pushing for more traditional values to be taught in schools, and they typically want better disciplinary action against those who commit serious violations of the law and or school policies. And finally, religious influence, in spite of the modern consensus and legal quote-unquote definitions, were never meant to be barred from the public square. The textbook suggests that the public school system should be barred from including any religious explanations at all, and the Supreme Court has decided this. I would argue that they should all be presented fairly, religious and secular, with corroborative evidence, and that the teacher should let the students decide which viewpoint is the clear and obvious choice. That's the idea of freedom that is embodied in the Constitution and the Declaration of Independence. And that's my summary. And I had some review questions here, but evidently my PowerPoint did not save those into it. So a couple of things that I thought about. I don't have these in my PowerPoint because it didn't save that final slide that I made. So I suppose some questions could be, when we look back over the slides, let's look back over the slides. Teachers must balance. Let's see. Teachers must balance rights with responsibilities. There we are. Slide number 5. So how do teachers balance rights and responsibilities in and out of the classroom, both in the classroom when they're teaching in the institutional setting and when they're in their personal life? That could be a question to ponder. Another good question is of the same vein, but it has to do with students. How can students find this balance? Because students also have to do this. They have a responsibility to live in peace with their peers, but they also have a responsibility to stand up for their rights. So, how far does rights go? How far do rights go? That's another thing. And so, that's a couple of review questions I think about. Also, what is the definition of Establishment Clause? I would challenge you guys to look at that and research that, because the Establishment Clause, its definition has been eschewed by many things over our modern society. But an honest reading of history and if you really dig into what the founders believed, they did not believe any of this that is presented as modern fact. They didn't believe any of that. So I would challenge you to question the definition of the Establishment Clause that has been put forth by the modern legal system. What's that definition? And then, finally, what what ways can more disciplinary action against those who commit serious violations of the law and or school policies, what disciplinary actions can school administrators and teachers take that would be both pleasing to parents to satisfy their desire for more traditional values and more firmly handed discipline, and at the same time protection of students. Obviously, we don't want abuse going on in the classroom. That's a given. There's to be no abuse in the classroom. If a teacher's abusing a student, they should be fired and kicked to the curb. I agree with that. That's non-disputable by me. That's non-disputable. And so those are some questions to ponder. I hope you wrote those things down. I apologize. I had them in my slides, or so I thought. It did not save that slide, so that's the only slide it didn't save. But I hope you wrote those down. You should be able to pause this audio. I'm gonna make it where you should be able to pause it, so you can write them down as I go if you need to take notes on it.